Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. I want to share with you basically a few announcements, but before I do that, I want to be sure and introduce your panel for this morning. Your panel will consist of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. As I look out, I am aware that most everyone's been here before and understands the process, but I want to basically run through a couple of things to make sure that everybody has a good understanding. First of all, I want to share that we're live streaming these arguments. So think carefully about what you say, because once it comes out of your mouth, everybody gets to see it, and we can't pull it back. So just be aware of the fact that we are live streaming. Second thing is I want to touch on our procedure. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, after you come up to the podium to begin your argument and after you've introduced yourself, you can request that from the court. You can reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. Finally, there is a monitor on the podium. The monitor is rather straightforward, and I suggest you use it. So long as the light is green on the monitor, you've got plenty of time. Once the light turns yellow, you're running out of time, and once the light turns red, you are out of time. And we ask that you please respect those time constraints. Ms. Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the first case, please.
Madison Holdings, LLC et al. Versus the Cato Corporation.
Okay. Ready.
Good morning.
Good morning.
Clay Culpepper here from the law firm of Evans Petrie on behalf of the appellants, Madison Holdings and Hammett Regency Plaza Limited Partnership. If I could please reserve 4 minutes.
4 minutes, all right. You may proceed.
This particular case, briefly some background. This started off as an FED. Madison Holdings is the landlord that I represent at the Vinings Shopping Center here in Jackson, Tennessee. This started off as an FED for non-payment of rent in General Sessions Court, was removed to Circuit Court, at which time the defendants filed a counter complaint for breach of lease. And what this case really revolves around are two particular articles in the lease. Article 25, which is a major anchor tenant provision, and Article 27, which is a competitive stores provision. At the time that these two parties entered the lease, back in 2011, the major anchor tenant at the Vinings Shopping Center was TJ Maxx, and Cato, the defendant appellee in this case, was on one side of TJ Maxx, sharing an actual wall with TJ Maxx. At the same time that they entered this lease, Holidays Fashions, a women's apparel and accessory store, was also in the center, and they were on the opposite side of TJ Maxx, sharing the opposite demising wall. Article 25 of the lease required the major anchor tenant to be TJ Maxx or some similar tenant, and if the landlord could not keep TJ Maxx or find a suitable replacement, Article 25 of the lease provided certain remedies to Cato. Now, these are some very important facts for the application of an analysis of the law under acquiescence and estoppel that I've put forth. And that is, in May of 2015, TJ Maxx vacated the center. The trial court held that Cato had both actual and constructive knowledge of TJ Maxx's departure. Admittedly, Madison did not provide the required notice to Cato of that departure. Not only was Cato the next door neighbor to TJ Maxx, but Cato's own internal weekly reports that go up to the executive levels stated that TJ Maxx had left, and then a few months later that this Ollie's Bargain Mart had replaced TJ Maxx. Cato never objected. They never said anything, despite having that knowledge, despite being next door neighbors. A few years later, 3 years later, in mid to late 2018, with an upcoming lease renewal, Cato did not, or reached out to Madison to renegotiate terms of the lease relating to the rental payments. Again, did not mention any change in major anchor tenant. In February 2019, Cato affirmatively renews the lease. Again, no mention of Article 25, no mention of a change in major anchor tenant. Then in March,
Well, in that letter that they sent in the renewal, they were asking, is that the letter where they were seeking a reduction in rent?
there were some emails in 2018 where they sought reduction in rent, and then the landlord denied that, and then they sent a letter affirmatively renewing the lease shortly thereafter.
Right, and in that letter, which was not required,
Correct.
in that letter, in addition to advising that they were going to renew the lease, they also had language in that letter stating that they intended to, not to waive any aspect of the lease and to enforce the lease in its entirety. That may not be
That's
an
accurate.
accurate statement, but it's
That's
paraphrased.
correct. That's
is
correct.
that accurate?
That is.
Okay.
But there was no mention, again, of any change in major anchor tenant. They affirmatively did renew that lease, and then in March of 2020, they sent a letter to Madison in reference for the first time, 4.5 some odd years later, hey, TJ Maxx is no longer here, Ollie's is not suitable, we're claiming our rights under Article 25. Yes, we've renewed the lease, but we want half rent, $250,000 rent credit for the past 4.5 years that TJ Maxx has been gone.
The lease also has a non-waiver provision.
It does. So the lease has a non-waiver provision, and I think as we begin the analysis, just a foundational cardinal rule of contract interpretation is ascertain and give effect to the intent of the parties. And a large part of this case deals with the concept, at least as it relates to Article 25, of acquiescence. And the Court of Appeals has held acquiescence to certain conditions is indeed evidence of the intent of the parties. It's Hodges versus Cornelison, Tennessee Court of Appeals, 2004.
You're not saying the lease is ambiguous, are you?
Well, I'm not saying that the lease is ambiguous, and what I'm saying is that even if the lease is not ambiguous, the Court of Appeals, the trial court, is not barred from looking at extrinsic evidence to gather the context. And in this case,
Here we've got a lease.
correct.
And I'm assuming that both parties agree this is a lease.
Yes.
And it's controlling. And the lease says what it says. And the lease has got a non-waiver provision.
It does.
And the trial court said, as I understand it, that the non-waiver provision's valid, so here we go. So are you saying the trial court made an incorrect factual finding or interpreted the lease incorrectly?
Well, what I'm saying is that the trial court applied the law incorrectly. Even in the face of the no waiver provision, courts have...
Who drafted the lease?
Cato, the tenant, drafted the lease. Now, the record will show, because I want to be clear, that there was some negotiation on some principal terms, but the record also shows this was Cato's form lease that they used. And yes, there is a no waiver provision, but no waiver provisions can be waived. And I'll jump to that.
They are valid in Tennessee, aren't
They are valid, of course, and in fact, there's a statute on it. But in spite of that, the actions of the parties can still affect a waiver. In fact, Sharp versus Valley Forge Life Insurance, this is a district court case of 2007. Court notes a policy, this is an insurance policy, obviously. The court notes that policy terms contain a no waiver provision. Specifically, the policy states no one has the right to change any part of this policy or to waive any of its provisions unless the change is approved in writing on the policy by one of our officers. However, the Tennessee Supreme Court held a written contract may be changed by parole, and this, although it stipulate that it shall only be changed in writing for the obvious reason that men cannot tie their hands or bind their wills so as to disable them from making any contract allowed by law and in any mode in which it may be entered into. This Davenport case, Tennessee Court of Appeals, 2006, the court found that waiver of an acceleration clause due to repeated acceptance of late payments without penalty was upheld despite a no waiver clause being in that contract. So these no waiver clauses, if the clear acts of the parties contradicted, can still be waived under the law of Tennessee.
This non-waiver provision did require that it's binding unless given in the form of a written instrument signed by the party.
It did. That's correct. And what I would argue, one, in spite of that, the acts of the parties still are contrary to the terms of the lease and the waiver. And the fact that you now have 4 some odd years passing, you've got actual and constructive knowledge, and what's more, you've got an affirmative renewal of the lease. So you're now renewing a lease with what amounts to an impossible term in that lease. You're renewing a lease that requires TJ Maxx to be in the center. TJ Maxx is not in the center at the time of renewal. TJ Maxx hasn't been in the center for 4 years, 4+ years at the time of the renewal.
Let me ask you, was there actually a new lease executed?
There was not.
In 2019? So
No.
you refer to it as being a renewal, but it's just an extension really of the original lease, isn't it?
Well, I'm using the language of the contract, which called it a renewal, but depending on how it's looked at, it's an extension of the original terms of the lease. Yes. It is not a newly executed
And
lease.
so nothing was signed in 2019 indicating that Ollie was the anchor tenant? There's no document?
That's correct.
signed at that time?
That's correct.
Okay.
That's correct.
Let me ask you,
No, go ahead.
you said it's Cato's lease. What, is that entirely true, or was it just Cato's inputting Article 25 and 27 in the lease?
I believe the record states, when questioning the executive on behalf of Cato, that this is their base lease, their form lease, the tenants, Cato's base lease. And there were particular items, obviously, the amount of the rent, and certain things that were negotiated between the parties, but the lease itself was drafted by and is Cato's form lease.
Well, so when this lease was entered into in 2011, I mean, your client realized that if TJ Maxx left, you couldn't just replace him with Ollie's. You had to replace him with a tenant that was either a national or regional tenant that sold clothing, in effect.
Well, probably. I would assume that they probably, yes, knew that at the time in 2011. And
Which is rather restricted, the ability to find another tenant like
That's
TJ
correct.
Maxx.
in fact, I can't think of any, maybe Burlington Co-Factory. I mean, there's probably not many, you're right.
I'm sorry.
Go ahead.
I'm done with that.
Your time's up, but I have a question I want you to ask.
Sure.
I wanted to ask you, you indicated that we're talking about primarily 25 and Article 25 and 27.
Correct.
Would you agree that the damages that were incurred here against your client arose pursuant to Article 25?
The damages, yes. Yes. I'm trying to think through. I mean, the damages arose through Article 25.
That's the non-payment of rent because of TJ Maxx.
Yes, that's correct.
And then this 27 applies to City Gear.
That's correct.
And so by the time City Gear came on, all of these damages had been incurred.
That's correct. The City Gear damages are a prospective, yes,
That occurred later.
that's correct.
Thank you.
Well, let me ask you, do you agree that they're damages, or is it your argument that they should be an offset against future rent, which is very different? I mean, if you call them damages, then maybe you're entitled to pre-judgment, post-judgment, interest, and all of that. What's your argument about that?
Well, if I understand your question correctly, let me start with the premise that, I was the original plaintiff, so we're seeking damages for non-payment of rent from Cato. With respect to Cato's damages, our alternative argument is if the trial court is correct, and if the trial court correctly held my client in breach, then their remedy, Cato's remedy, is an offset, not a money judgment. They get an offset, which is what is prescribed in their own lease.
Okay. All right. Thank you.
Thank you.
Thank you.
You still got your 4 minutes rebuttal time.
Thank you.
Morning.
Good morning.
May it please the court, Brandon Reedy here on behalf of the appellee, the Cato Corporation. We ask this court to affirm the judgment entered by the trial court, which properly found that Madison violated Article 27, the competitive stores provision of the lease, Article 25, the inducement provision of the lease, and properly found that Madison's affirmative defenses did not apply here, and that the resulting remedies were also proper. Touching on a few points that were questioned here and also raised in the reply brief.
Can I just ask you, since we were talking to Mr. Culpepper about this issue, the amount of damages that were awarded, I just want to see if you agree with this, that were awarded pursuant to Article 25 of the lease, the TJ Maxx issue, not 27, which is the City Gear issue.
Right. The money judgment that was awarded is based on the overpayments that Cato had made in rent due to the TJ Maxx Article 25 violation.
Okay.
When City Gear came into the picture in October of, I think the lease was signed October 30 of 2020. At that point, Cato elected that remedy. It's a different remedy, has different provisions that apply there, but elected that remedy, and it kind of affected the way that the credit balance had built up. But yes, the actual dollars are due in part to a violation of Article 25, and then also there was some common area maintenance fees credits that were owed, and roughly about $25,000 of that judgment was CAM fees that were owed.
But that was still applicable to that time frame involving TJ Maxx.
The CAM
Charge.
CAM charges, yes.
Thank you.
On the topic of Article 27, the competitive stores provision, as I mentioned, while this lawsuit is pending, the parties had filed competing motions for summary judgment. Madison, the landlord, enters into a lease with City Gear, and we contend, and the trial court properly found that City Gear is a competitor of Cato's It's Fashion Metro store, and the defenses that have been raised by the landlord in response to that, we believe, do not apply for several reasons. But one of the points I wanted to make sure to clarify in the appellant's reply brief, they try and kind of dismiss the fact of the locations of these stores. When you view this store, it's actually about 3 miles from here. But in the middle, we used to be TJ Maxx, now Ollie's. It's roughly 27,000 square feet. Immediately to the right of Ollie's, if you're facing it, is Cato's It's Fashion Metro store. And then to the right of Cato, on the far right end, is the City Gear store. I believe in the reply brief, the way it's positioned and argued is that they're both kind of sandwiching in this Ollie's location, and somehow the Holidays store that they're saying was the replacement in kind somehow equate the two. They're not even close to each other. Holidays was not a neighbor of Cato. Holidays had a restriction in its lease, a use restriction to only sell women's clothing and apparel. And City Gear, on the other hand, has essentially the same product offerings as Cato's It's Fashion Metro store, and they're located directly next door to each other. And it's about 75% larger than the Holiday store that was there originally. On the topic of whether this was a replacement in kind, essentially landlord argues that for purposes of Article 27, that City Gear was a replacement in kind of Holidays, which left years earlier. And the reason being, they're saying that you should ignore the fact that it's larger and ignore the fact that there's use restrictions in the lease. And we contend that that's just doesn't apply. It ignores the language of the lease itself, and it ignores the stipulated facts and the testimony in the record. The provisions of Article 27 that address this lay out specifically what a competitor is. It defines the term competitor. And then on top of that, it goes on to say that the replacement in kind language and the restrictions for competitor stores doesn't apply to an existing tenant. However, the landlord, if they have control over use restrictions, must enforce those. And so to the extent they're trying to say that years later a new tenant can come in with broader use restrictions, that simply just doesn't apply. Therefore, we believe that the trial court properly found the landlord in violation of Article 27 and that the resulting remedy from Article 27 is proper. Jumping to Article 25, which is kind of the meat of this argument, which is the TJ Maxx issue. As was mentioned, the trial court found that Cato had actual and constructive notice that TJ Maxx had left and that Ollie's had come in. While we can accept the constructive notice finding, we do disagree with the actual notice finding in the sense of we believe that the evidence that's in the record and the testimony and the stipulated facts that were presented before trial ponderate against that finding.
Were there any discussions, did the evidence reveal any discussions between the parties regarding this issue?
Regarding TJ Maxx and Ollie's going back and forth? No actual discussions, communications between the parties regarding that.
It was just that each side was aware of.
That's essentially what it came down to. And the awareness from the landlord obviously being signing, executing these leases. That's one unique factor on the landlord side is the individual. It's essentially one person operating as entities. But Mr. Rabin Michael actually signed Cato's lease that was signed back in 2011. So he was there when that happened. And earlier the questions was asked, was this Cato's lease? Should this be construed against Cato as the drafter of the lease? Cato did come in to negotiations for this spot in this shopping center with a form lease, but it was heavily negotiated. And that's in the record, and the testimony's in the record. And I believe that's volumes 5 and 6 of Mr. Michael talking about his involvement in those negotiations, and then Cato's representative discussing the negotiations and how the terms in this specific lease don't align with Cato's standard lease that they would normally want in a shopping center.
In conjunction with what Judge Stafford asked earlier, there was no finding that this lease was ambiguous, was there?
There was not. And I believe throughout the process, we pretty much both sides until now, I believe. I don't want to speak for Mr. Culpepper, but I believe everyone was pretty much on the same page that this is an unambiguous lease. Judge Morgan, throughout his findings, I believe one of the first things he says is everyone agrees this is clear and unambiguous. It's a long lease. It's very, it's got a lot of language in there, but luckily it's very specific, defines the important terms that we're here about today, and I believe removes any type of ambiguity that is argued on behalf of the appellant.
So when does the record reveal that your client first asserted its rights under the lease as to the reduced rent?
Okay. As to Article 25, this major acre tenant provision, that was in, I believe, March of 2020. There's a letter in the record. The way the trial exhibits are in the record is kind of confusing, but the trial exhibits are found at volume 8 and 9. It would be in volume 8. I can find the specific exhibit number for you, but there's a letter that Cato sent in March of 2020 stating that we've now know that there's been a violation of Article 25, that TJ Maxx has left. We were never provided notice. Article 25 allows us various remedies, including, but not limited to, the ability to set off future rent payments against any amounts we've overpaid to date.
And TJ Maxx left, what was the date, the agreed upon date?
TJ Maxx ceased business at the center in May of 2015. Ollie's and the landlord entered into a lease in December of 2015, and then roughly, almost exactly a year to the day, Ollie's opens in the center in May of 2016.
So is May 2015 the operative date that the trial court worked from?
For what purpose?
that TJ Maxx left?
As far as determining the remedy amount?
Yes.
Yes, and you count forward, I believe it's, I think the language of the lease is 30 days after the violation, so you kind of have to track that. I believe it's laid out in the order pretty detailed as far as
But
the
that,
time.
that's essentially the, I don't want to call it breach, but maybe that is
Right.
the occurrence date.
Right. And then as far as the finding of actual and constructive notice, Judge Morgan found, and this is volume 3, page 413, in his final order, that Cato had actual and constructive notice of TJ Maxx leaving the center, Ollie's coming into the center in June and/or September 2018. I guess not or, June and September 2018.
So that would, 3 years after.
Right. The finding is not specific as to the date that they're gone. Cato knew. It does say that Cato had internal reports that say TJ Maxx left, TJ Maxx closed in Jackson, Tennessee. This report you'll see in the record has columns, and one says in same center, same shopping center, and the other says same town or same city. It says TJ Maxx left, and that's in the column of same city. So Mr. Doyle testified, that didn't raise any alarm bells at that time because there's TJ Maxx everywhere. And mind you, Cato's in North Carolina and doesn't know the unique situation of Jackson, Tennessee. And then roughly a year later, when Ollie's comes in, it's in the column of same center, Ollie's opening for business May 2016. So those two things on their face to show that a TJ Maxx left Jackson and that an Ollie's is now open in our shopping center. That didn't seem to bother anyone at that time because you wouldn't know that TJ Maxx is no longer specifically in this center. When this kind of came to light was when we first learned that City Gear was possibly coming into the center, which we believe to be a competitor. There was kind of a full evaluation done of this lease and this center, and at that time we noticed, wait, our major anchor tenant, TJ Maxx, is no longer there. And that was when the letter in March 2020 was sent saying we've discovered this violation and we're claiming our remedy at this time.
Well, the manager of the Cato store at that location would know from the change in signage that TJ Maxx had left, and then when Ollie's entered again, there would be new signage that would indicate the store that was present, what was all the anchor space. Isn't that true?
The folks at the local store level would, an hourly employee or a store manager. However, Tennessee law, I believe, is the way in this circumstance states that having that knowledge, it has to be within the scope of your agency as an agent of a principal. It's not within the realm of this person's responsibility or obligations to then notify Cato's corporate real estate department in North Carolina of those types of happenings at the local store level. And the lease specifically provides for those notice requirements and to notify Cato's real estate department when these significant changes occur for that purpose.
So what's the disparity, or what was it that triggered the knowledge on behalf of your client? Because we've got, 2 years, 3 years difference of when TJ Maxx left and when it was determined that your client was aware that TJ Maxx left.
Right.
Did the trial court differentiate that?
What triggered the knowledge of when that occurred?
Yeah, why did the trial court, or what did the trial court find, I guess, convincing to determine that your client only gained knowledge in, I think you said 2018?
That's the specific finding as far as a date when they did have actual constructive knowledge that's in the record is that June and September.
TJ Maxx had left in 2015?
2015, and then Ollie's had come in 2016.
But your client didn't know until 2019?
Right, and based what it is these internal reports that did make their way to the corporate level didn't specify specifically that it left this center.
And I think perhaps you've answered my question, is the trial court was looking at the reports.
Right.
Okay.
And then essentially the argument that was presented at that time was, and is still presented, is that in 2018, when these emails are sent on behalf of Cato requesting a reduction in rent before the first renewal period starts, they were going to let it automatically renew. There's a letter sent to that effect. But they're trying to negotiate with the property manager, can we hold the rent where it is and not increase it by 50 cents a square foot for the next 5 years? And we argue that this preponderates against that's evidence that preponderates against the trial court's findings that there was actual notice, because it makes, in our minds, it makes no sense that in 2018, we would be, begging the landlord for a 50-cent reduction in rent when we have roughly $36,000 a year of a reduction in our back pocket that we decide not to enforce until 2020. It just simply doesn't make sense under these circumstances. When we did discover this is when the city gear issue came up. There was kind of some rumblings of that going on in March 2020. We learned this, sent the letter, took the remedy, and we believe that we were entitled to do so at that time. Another point I wanted to touch on that the court addressed was the non-waiver provision. That essentially became a very significant portion of Judge Morgan's conclusions of law in the order, in that all of these equitable theories, what they came down to is essentially there's a lot of time that passed, we're prejudiced here, and Judge Morgan essentially said they had the right to renew. There's a non-waiver provision. By statute, that's enforceable. We must enforce it here. And this idea that now we have an impossible condition that's been argued simply doesn't make sense, because Article 25 actually contemplates what appellant calls an impossibility. Article 25 contemplates a situation where your major anchor tenant's gone and the tenant, Cato here, gets a reduction in their rent, even going through the first renewal period. The language in the lease talking about that remedy says that effective February 2023, Cato has to pick a remedy. You either have to pay full rent, or you have to basically agree to terminate this lease because you can't stay on, this reduced Article 25 half rent remedy, infinitum. And so we believe that this court should affirm the trial court's finding as to the violation of Article 27 and 25, the finding that these affirmative defenses did not apply and that the resulting remedies were proper. Thank you so much.
You have 4 minutes.
Thank you. Since I didn't really address Article 27 in my initial argument, Article 27, the competitive stores provision, does contain, again, it's our position, and I think the record is clear, this is their form lease, and it contains an exclusion to that competitive stores provision for replacements in kind. It doesn't tell you what the square footage has to be, doesn't tell you what the location has to be. There's no reference to either of those. There's no reference to time lapse. The difference, for the court's knowledge, and it's in the record, the difference in the square footage between Holidays, the original apparel store, which was around 5,000 square feet, and City Gear is 6,500 square feet. So there's about a 1,500 square foot difference. But Cato's lease doesn't say they have to be the same square footage or within some realm. So they're both apparel stores, and it's our position that City Gear is an appropriate in-kind replacement for Holidays, which was in the center when Cato signed their lease. With respect to notice, the court had a lot of questions about TJ Maxx leaving the center and what did the trial court understand to be notice to Cato. Well, weekly reports are conducted by a vice president, a regional vice president of Cato, who not a store manager, not an employee of the local center, but a regional vice president who sends these reports to the executive team in North Carolina, who has weekly meetings. That's what the court said. You've got these reports, you've got actual and constructive notice of both TJ Maxx's departure and Ollie's coming into the center. And as I understand it from the record, that notice was as of May of 15, not sometime in 18. And then the last point I'd like to hit on, outside of any questions the court may have, which has not been discussed, is this concept of the voluntary payment doctrine and the fact that Cato made these payments over the course of 4 years and now is wanting them back, essentially. And the court, the trial court, really didn't address the voluntary payment doctrine. The trial court's order didn't really state why he wasn't going to, he just said it didn't apply or wasn't going to address it. And in the face of the appellee's arguments that it wasn't originally raised as an affirmative defense, that's the first time the appellee has made that argument. And I think it's too late under the law of Tennessee raise that argument now. The trial court didn't have any issue with,
Are you saying it was raised in the trial court?
it was raised at the trial court level. It wasn't raised in the answer as an affirmative defense, but it was raised at the trial court level. The trial court just didn't.
How was it raised at the trial court level, if it wasn't raised in the answer?
It was raised in argument, and I believe it was also raised in the trial brief. Argument at trial. And
Let me ask you this.
Go ahead.
What do you think the court was saying in the order of final judgment when it said, I want to make it very clear that I'm not making any finding in favor of the lessor's defense of voluntary payment. I don't think that clause is a proper defense on the facts of this case, voluntary payment.
My assessment of that was that the trial court didn't think the defense applied. I didn't see it as a procedural non-application. If that's what he intended, that's not what I read into it.
Well, is that ruling against your argument about the voluntary payment doctrine?
Well, as Judge Golden just read, that's all the mention of it there is in the order. So, in the fact that he refused to apply it, I take that as a ruling against the application of the voluntary payment doctrine.
But you think it's insufficient and that there are further findings concerning
Correct.
your defense of voluntary payment?
That's correct. That's correct, Judge.
All right, thank you.
Thank you.
Thank you, counsel. We appreciate your briefs, your argument. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time.
Thank you.
Thank you. You may be excused.